Welcome to 6 Questions from 6. Today we're talking to Rachel Deutsch from the Center for Popular Democracy about the Fair Workweek policy landscape in 2020. Let's get started.
So this is question number one. Can you please introduce yourself and tell us a little bit about the Center for Popular Democracy and why this push for fair workweek policies is an important progressive issue?
My name is Rachel Deutsch, and I'm the Supervising Attorney for Worker Justice at the Center for Popular Democracy. And we're a national network of organizing groups. We mobilize low-wage workers, immigrants, communities of color, and among other things, our staff works closely with these communities to develop and advance policies that are rooted in their lived experience and address their most deeply felt needs. And we've been on the front lines of the fight to raise the minimum wage and earn sick leave, but our members have told us loud and clear that they also need stable work weeks in order to earn enough to pay their bills, to invest in their futures, and to be there for their families. So we hear that ever-changing schedules, last-minute shifts, and involuntary part-time work are taking a really huge toll on working people's financial security and their well-being, as well as their families. And we see an economy that's really out of balance, and corporations are monopolizing workers' time. So the Fair Workweek movement is motivated by the belief that all working people should be able to live with dignity, that their time counts, and that we can restore some balance to the work week in these growing low-wage sectors that are an increasingly important part of our economy.
Okay, great. Question number two. In which states are you seeing fair workweek legislation introduced, and have these bills had any bipartisan support?
So the first state to pass a Fair Workweek law was Oregon. They passed a bill in 2017, which took full effect this year. And the law in Oregon was passed with bipartisan support. Bills have been introduced in a number of states over the last 4 or 5 years, including in Massachusetts, Maryland, Washington, Connecticut, California. We expect a bill to be filed in New Jersey in January. I would say the states to really watch in the 2020 session are Connecticut, New Jersey, and Washington.
Great. And question number three. Generally, what do these bills do?
So first, it's important to note that Fair Workweek laws apply to large businesses in the service sector. In Oregon, the law applies to retail food service and hospitality companies with at least 500 employees. And in many cities, there are additional sectors, and in some state bills, additional sectors such as healthcare, warehouses, and janitorial services. But it's important to note that unlike other laws such as minimum wage, where we're really trying to cover everyone, the problem of just-in-time scheduling that we're trying to address with these policies is really prevalent in sort of certain sectors, and that it's most egregious when conducted by large businesses. So the laws have 4 essential components. The first is predictability, just knowing when you're going to work so that you can plan your life around it. So there's a provision around getting a good faith estimate at the time that you are interviewing for or being hired for a job, so that you have a way of knowing approximately how many hours you're going to work in a given week, generally when you will work or when you will be off. The policy requires that employers provide an actual work schedule 2 weeks in advance, so people can plan their family life and their personal obligations and their studies around their work hours. And then after the schedule is posted, the employer can still change the schedule, but workers are entitled to compensation for changes that are initiated by the employer. And employees, of course, can still swap shifts if that's agreeable with the employer. The second component is about the right to rest between shifts. So in the service sector, workers often experience these brutal clopening shifts where they close the store late and they turn around on very little rest to come back for an opening shift. So closing plus opening, clopening. And these laws give workers the right to decline clopening shifts. And if they agree to work a clopening shift, then they would receive extra compensation. And third, the laws address the crisis of underemployment in the service sector. So the SHIFT project at University of California found through survey data that a third of all retail and food service workers are stuck in part-time jobs and they really want to work more hours. And for companies like Walmart, Target, Chipotle's, keeping a large part-time workforce is actually a key part of their just-in-time scheduling strategy because they know that workers will agree to last-minute shifts because they're desperate for more income. So it's really important that these policies address these problems of insufficiency of hours and unpredictability of hours together. And so this policy simply requires employers to offer more full-time opportunities to their part-time workforce before they hire new additional staff. And then the fourth element is just giving employees a voice in their schedule. So prohibiting employers from retaliating against workers for requesting schedules that accommodate their personal and family needs. In some cases, there may be additional requirements around actually granting those requests when it's compatible with the business needs. In other places, it's simply prohibiting the retaliation, whether or not the employer actually grants the request.
Great. Question number 4 is, what are some additional policy options that state legislators should consider?
Well, not only are part-time workers often needing more hours in order to pay their bills, they're typically paid less per hour than their full-time counterparts. So that's an extra financial hit. And they're often ineligible for promotions. And the part-time workforce is overwhelmingly women. So it's an important part of the women's economic security agenda to address this sort of part-time crisis. Some policies have a provision that we refer to as part-time parity that says that part-time workers should have equal pay and promotion opportunities comparable to their full-time counterparts. Enforcement is also very, very important because these rights really won't mean much if they aren't enforced. And state enforcement agencies are already stretched so thin. We also are seeing an increase in the spread of forced arbitration clauses in employment contracts, especially for employers in this service sector. Larger employers are requiring workers to waive their right to go to court and enforce their rights. And that places an additional burden on enforcement agencies as the last resort for all of these workers who have been forced to give up their right to enforce workplace protection. So we really recommend including what we refer to as whistleblower enforcement provisions, which it's a very cost-effective way to increase enforcement capacity by letting workers play a role in collecting penalties from law-breaking employers.
Okay, great. Next is question number 5. What are some of the legislative tactics used by the opposition to fair work weeks, and what are good ways to respond?
So the opposition to this policy has really evolved over time. We would hear a couple years ago from employer associations that this is a solution in search of a problem, that their practices were perfectly fine and workers really enjoyed, we hear often this phrase around workers seek out jobs in the retail sector or food service sector because they like the flexibility. And we fortunately now have really unimpeachable data that shows that that's just not true. Workers have very, very little control over their schedules. I think about 80% of workers in these sectors say they don't have input into their schedules. And so the flexibility is really a one-way street, right? It's employers demanding flexibility from their workers. And the data really shows the very extreme impacts that are very negative on workers and their families. So employers have sort of shifted in many cases from outright opposition, saying that this policy is not needed, to trying to sort of cast doubt on how effective the policy is, but primarily really trying to whittle away at the bill, right? So if you're in a position where you have enough support to pass a bill, the strategy will be primarily trying to kind of riddle it with exceptions, right? Have so many loopholes that it doesn't really require them to change any of their practices. And it's important to note that the policy seeks to preserve flexibility for employers. So it's not about saying the schedule is set 2 weeks out and it can't be changed. It doesn't say you can never schedule somebody for a cloak opening shift. the policy really relies on compensation to employees to discourage those practices and to ensure that when they're really necessary for business operations, that at least flexibility on the part of the workers is being compensated. But then we see employers really fixate on the compensation as a penalty, right? And demand exceptions and talk a lot about, what about this? What about that? Naming different circumstances where the need for a schedule change, for example, is not really their fault. And so then you'll see pressure to really add a lot of exceptions. And those exceptions can really limit the bill's impact. So for example, the voluntary standby list that was included in the Oregon policy is really a pretty enormous loophole that can undermine the goal of providing predictable schedules, since employers will still have every incentive to add shifts at the last minute. So I'd say, as if you're considering sponsoring legislation like this, it's important to have someone on your staff really be able to take the time to understand how any policy compromises will impact the managers who are going to implement the law, the workers who we're relying on to bring complaints, and the staff at your state Department of Labor who will investigate complaints. Having a very, very complicated fact-specific set of exceptions is really going to add to the enforcement burden. And I would say, as a sort of legislative strategy, it's also very important to keep the focus on workers. The big corporations that are subject to this law don't really need these exceptions, right? They're very profitable. They're going to be just fine, even if they have to pay 1 hour's worth of wages to compensate somebody for picking up an extra shift. And really, it's the workers who are juggling multiple jobs, taking buses for 5 hours a day to get to 2 different part-time jobs, that really need these protections and that need to have pretty clear-cut rules so that they can know what their rights are, insist on their rights. So I would say really trying to keep pivoting away from corporations trying to make this about the burden on them, and recognize that we're trying to restore some balance to the work week here, and we can't do it if we keep kind of chipping away at the protections.
Okay, great. And the last question, question number 6. What advice do you have for legislators who are considering fair workweek legislation, and where can they go for additional resources or technical assistance?
So one key piece of advice, I really recommend to reach out to community and labor organizations that have workers who are impacted by the policy. For example, sometimes folks will ask, well, which sectors should we cover? And there are sectors, as I mentioned before, that are traditionally covered by the policy, but really the key thing is cover the sectors where in your state there are organizations capable of mobilizing working people to talk about why they need the policy, because the companies that are going to oppose this will have a lot of lobbying resources. It's really, really important to partner with unions, with community organizations, organizations that advocate for access to childcare are often very concerned about promoting these policies because there's so much data linking unstable schedules to bad outcomes for kids, right? So really bring in your coalition and make sure that they have some capacity to speak up in favor of what you're proposing. Otherwise, your colleagues will only be hearing, from the Targets and the Walmarts and the, fast food industry. And then, I think really having strong kind of communication that we try to use the term fair work week. You may hear the term predictive scheduling. That's a term that employers invented to kind of try to avoid the fact that predictive, I don't think, is a word, right? It's just that they don't even want to say predictable, because then it would acknowledge the fact that they are, keeping workers in complete turmoil with unpredictable lives. So I think, spending a little time thinking about the right way to frame the issues can be really, really helpful here, because this is still a very new issue for a lot of legislators and, really requires some education. The Center for Popular Democracy's Fair Workweek initiative has a wealth of materials that we can share, model policy, explainers, et cetera. I think that the SHIFT project's data points are very, very valuable in quickly breaking down what this really means for working families. And we're also very excited to be partnering with SIX to create a sort of overview that can help folks walk through. But we are here to help, and we're happy to review proposed legislation and provide our technical assistance whenever possible.
Thanks, Rachel. Legislators, please reach out to helpdesk at stateinnovation.org for support on this and any other issue. Until next time.